ultimately, and here's a unique aspect of this process compared to the FMLA in particular, the insurance carrier, not the employer, determines benefit eligibility. That is similar to disability benefits, for example. The big distinction here and the kind of potential complexity is that New York State disability benefit technically isn't a leave eligibility event. While for various reasons, it's often not a good idea to separate someone from employment while they're on disability. Technically, you can do that because they're not guaranteed leave. They're only entitled to the benefits. And likewise, when you do separate someone on disability from employment, that doesn't necessarily prevent them from continuing to get the disability benefit. Of course, paid family leave is both a benefit and a leave statute. So the employer has to allow the employees to take the leave, where the insurance company has to pay the benefit, but the employer won't always know whether the insurance company is going to approve the benefit until after the leave begins, because the insurance company has 18 days from receipt of the request or the first day of leave, whichever is later. So even if the employee gives months worth of notice, technically an insurance carrier has 18 days after the leave begins to decide whether or not they're going to get paid family leave benefits. I'm not sure that it's that much of a hassle in most of those situations. Obviously, the non-foreseeable last minute application is more likely to create this issue, but effectively an employer is going to have to make independent determination of whether this person is eligible for at least some form of leave, whether it be FMLA leave or paid family leave, to determine whether they're going to let them be out of work without penalty pending any outcome from the insurance carrier. If the employee is denied benefits, they can appeal that determination all the way up through an arbitration process. And again, this is really employee against insurance carrier. The employer's role is on the sidelines, but you have a material interest because this person is either coming or not coming to work, and potentially whether they're getting benefits or not could affect what other forms of paid leave they're receiving or not receiving. So there are certainly circumstances where this becomes complicated. Most of the time, the best thing the employer can do is communicate with the insurance carrier to try to determine as quickly as possible what the outcome is going to be on the benefit claim.